What is the probate sale overbid process? Now, this thing, we get a lot of questions about this. We end up answering this question not only to buyers and sellers, but a lot to real estate agents. We'll get into that. But what happens? Does the judge come out and just starts auctioning off everything like artwork and cows? Does he come out and start talking real fast, like, oh, we're going to start at the bidding? Is that what it's like? You pull up a little sign every time, somebody he says $1, $2, $2. We're going to get into that right now. Welcome back to the channel. I'm Brendan Mohr, California Realtor and Certified Probate and Trust Specialist.
And I'm Bill Heyman. I'm a licensed California professional fiduciary. I'm also a registered and bonded legal document assistant in both California and Nevada, a licensed California real estate broker, as well as a licensed realtor in Nevada. And we want to remind you, as we often do, that we are not attorneys. We cannot give legal advice. Everything, all of our information that we give to you is strictly based on our more than 40 years of combined experience in the probate and probate real estate world. And if you ever have important legal questions that you need to have answers to, you should always consult with an attorney.
Now, every day we help people save thousands of dollars and headaches through our very unique one-of-a-kind probate administration service and real estate listing combo. So please reach out to us. We do that in California and Nevada. Our contact information is below, so please text, call, email, comment on this video, and please remember to like this video, subscribe to our channel because we release new videos every week and we can help you a lot. Now, the probate sale overbid process, Bill, now that is something that if the court grants the personal representative, the administrator or executor, limited authority, is something that ends up going on after an offer is accepted. And this is something that, we've been doing this for a while. And whenever we have one come up, we tend to talk to a lot of realtors about this and a lot of great realtors who have been around for a long time. And I've had ones that, don't know the process, who have worked in real estate for decades. They've never even done one. What would you say, is maybe one of the biggest challenges to this process?
I would say that the biggest challenge is probably getting the seller to understand, getting the buyer to understand that, yes, bidders can come into court and cause an overbid to occur, but it doesn't happen that often. And the reason that you don't get bidders in court that often is because we've marketed that probate property to get current fair market value for the property. So you normally don't go into court going into a bid process with this property that's way under market value. It just doesn't happen. If you did, then yeah, certainly you would get overbidders. But I think that's one of the biggest challenges, is to kind of reassure the buyer, especially if the buyers come in at fair market value, not to worry too much about overbidders, because they may not, likely they won't come in. And even if they do, the buyer can still bid himself in court. He can bid higher if he wants to. So a lot of buyers think that if an overbid comes in, they're out of the picture. No, that's not true. That's not true. The buyer still has an opportunity to bid higher if they want to. But the other thing that you have to understand, and I'll let you talk about that, Brendan, is the first overbid doesn't just come in at $1 higher than your current existing offer. Why don't you tell us about that?
Yeah. So, I suppose I'll start a little bit just with the process here. So the court grants limited authority. Then the realtor markets the home. Once you accept an offer, then whoever is handling the probate, I call that person a probate professional, because it could be a probate attorney, could be a non-attorney probate administration service, like what Bill does here, and petition the court for the hearing. You have to publicize the hearing notification. So all that process there takes a little while. So once you accept an offer, it can be 45 days. It could be 60 days. It could be longer depending on the court calendar.
Mhm.
Now, the date of the hearing, the buyer, the seller, and the agents for both the buyer and the seller need to be at the hearing. And we've seen more recently, depending where you're at least where we've done them in several different counties, you could do them over Zoom.
Mhm.
Now you can also go in person as long as that court's open. I don't know of a court that isn't open
Most of
now.
them are open now.
Yeah,
Yeah, most of them are.
but we've definitely seen that option where you could either do it over Zoom or in person. Now, and all any potential bidders can show up
Mhm.
during that time, and they would maybe know about it because of the publications. Perhaps they're searching court records for this type of thing. Now, the judge goes over the details of the contract that was accepted, being the offer that was accepted, and then he opens up bidding.
Mhm.
So at that point, he asks, "Hey, are there any bidders here?" Now, if there is, the first bid is the contract price plus 10% of the first $10,000. Now, 10% of $10,000 is $1,000. So, but that's just the way it's written out.
Mhm.
Contract price plus 10% of the first $10,000, and then 5% of the balance of the contract price. So, I know that sounds a little bit convoluted. So, an example would be a $500,000 contract, being that that was the accepted offer on the house. That's basically 10% of the first $10,000 is $1,000, and then 5% of the balance of the contract price, which is 500,000 minus the first 10,000 is 490,000. 10% of that amount is 24,500. So then you add those two together, that's 525,500. Again, I know that sounds a little bit complex. Another way to say it is contract price plus 5% plus $500. And that's what it typically turns out to be. But the way I said it before is the way it's actually written out
Yeah.
in the court codes.
Yeah.
So opens up that first bid. So say again, $500,000 contract. He says the first bid, 525,500. So you're 25,500 over the accepted offer price.
Mhm.
Now you have to consider that the home has been marketed to the public for we like to do it for typically at least a week. um, maybe it's been longer than that, but you're getting the market really looking at this home and
Mhm.
deciding what they want to offer. So to think that somebody out shopping for a home suddenly wants to come in 25,500
Yeah.
higher, that's why we typically don't see
Yeah.
them show up. And
Yeah.
the problem that can be is that a lot of buyers, uh, it gives them a lot of anxiety because one, it's a waiting
Yeah.
process. You do have to go, it can be a couple of months or so before that hearing. And then, well, what happens after? You'll say there's a bidder there, and he
Mhm.
goes, "Judge, I'll bid that 525,500." What's the
Mhm.
next step there, Bill?
Well, then the next step is obviously if there's other additional bidders there. If not, then the judge usually will set an increment for the next bids up. And it kind of depends on the value of the property and the situation, but it could be anywhere from $500 increments, 1,000, 1,500, $2,000 increments. But the judge will set an increment, and then the next bid up will be at that increment. So if there's other bidders there, maybe they'll come in at 526,500 if they're $1,000 increments. Now the buyer's not out of it at this point because if the buyer wants to bid, they can certainly bid. Absolutely. So essentially, the bidding will take place until no one wants to go higher than the current bid.
Yeah, and of course the buyer, the winning bidder, has to prove that they can actually make this purchase to the court at that
Yeah.
point. And it may depend on the court's rules that has jurisdiction over this particular probate. But a lot of the time, you actually have to have a cashier's check for 10%
Yeah.
of that purchase price ready, made out to the estate. So, what is typically advised is that if you're thinking about going to this hearing and you're going to bid, in that particular case, that 525, 500 be the opening bid. You'll know that beforehand that that's going to be the opening bid. You're going to want a cashier's check made out to the name of the estate. And if you're thinking about going higher than that, you're going to need to have additional cashier's checks for those bids coming up.
Right.
So make sure you have that.
Yeah. There is one other thing I just want to kind of make mention of, Brendan, in this overbidding process. And you mentioned it earlier in that, the judge is looking at the offer and what the terms are.
Mhm.
Believe it or not, a higher bid may not always get it. For example, if the contract price is a completely cash offer and the first overbid comes in higher, but it's not all cash, maybe he's going to give a 20% down with an FHA loan to make up the balance. Well, the judge may turn to the seller and say, do you want to accept this? Even though it's higher, the terms are not exactly the same and it may not be quite as advantageous. So that's another thing you got to watch out for. Are the terms of the overbid at least equal or more favorable than the original offer? Those are things that get taken into consideration at the hearing.
And that's a great point. There's a lot of great reasons for that. Say it was a cash sale, one that's more of a guaranteed close. You don't have to go through the lending process, which can be problematic depending on the condition of the property and the quality of the buyer, even if they have a pre-approval. May not be the case that's going to close. Cash, you don't need a loan contingency or appraisal contingency.
Yep.
But also the condition of the property. If you watched, we have a video called our probate sales cash only, and I talk about this where they're not all cash only, but condition of the property matters because FHA and VA financing, they'll only lend on certain conditions of the property. You can't have a whole bunch of safety problems. VA requires a Section 1 clearance showing that there's no active termite infestations. FHA and VA may call out all sorts of things like wood rot, tripping hazards, if the roof maybe doesn't look all that good. So there's a lot of reasons why a judge may turn to the estate and say, "Hey, this is a financed offer. It's higher, but
it's not a guarantee.
It might not even close."
Yeah.
Now, getting to the contingencies part, now that's another part of this. The process here for the winning bidder. Now, the winning bidder must be able to close on the property and does not have any contingencies protecting their deposit. So they're going to have that 10% deposit, and they have to close on it now. They have been ordered by the court. It's not like a regular real estate sale
it's a court order.
Yeah, it's a court order. So at that point, if they default on the sale, they go into the house and there's some sort of condition there that they don't like, that for whatever reason they just decide not to buy the house. Maybe if they had a loan, now their loan falls out. Well, they've been ordered by the court. Now you're forfeiting a 10% deposit. So that's a reason why.
And just to put on top of what you said, Brendan, not only will that buyer, when they're under a court order to buy that property after the hearing, if they default and they don't follow through with the sale, closing escrow, not only will they be out their deposit, but they might be subject to damages awarded by the court above and beyond that deposit, because the court and I've seen situations like this where the court looks at it, hey, because you didn't close and I ordered you, this is the judge, I ordered you to close, this estate has suffered damages and that deposit is not enough. You're going to pay more. So if you're a buyer going into overbid on a probate sale, you better be prepared to close once that order comes down. Better be.
Yeah. So if you are a buyer, just make sure you've done all your investigations. A lot of times, it's the buyer who originally got their contract accepted. Usually, they're doing some sort of inspections before that process. And I've seen blogs and videos saying that there are no contingencies allowed in probate, or in ones where the seller has limited authority and court confirmation is required, and that's not true at all. That's up to the estate. It's up and of course the agent involved is a part of that process as well. But yeah, you can have the normal contingencies. Sure. They just have to be removed
by the time you get to that hearing.
before they get to the hearing. And even if you haven't removed them, The court then orders whoever has essentially won the bid or won the contract to buy the home. Those contingencies are no longer valid at
Yep.
that point. So,
Yeah.
so even if you didn't remove them in writing, you don't have any contingencies anymore. The court told you to buy that house.
Yep.
Now, there's a lot of time in there, and maybe in another video sometime we'll talk about the timeline of limited authority.
Mhm.
But as far as the bidding process, that's the bidding process, and then once it closes, and the judge then signs the order. And once you actually have that court certified order of the sale in your hand, you can take that right over to the escrow company and you can close that day. Now, if you're at the court, they may be able to get it to you that same day, maybe.
Yeah,
Um,
courts are generally pretty good in those situations about getting you a certified copy right after the hearing. Generally, they're pretty good about that. But if not, I think you were about to say, sometimes that can take a week or two to get it from the court. So, you may not be able to close until you can get, as Brendan said, until you can get a certified copy of that order to title, you can't close.
Yeah, it's really important with whoever you're working with handling your probate, whether it's an attorney or a non-attorney probate administration service, like what Bill does, that they request that certified court order immediately, because that has to be prepared and sometimes picked up or mailed out.
Right.
And we actually had a situation where we were just working on the real estate side, and the estate was working with an attorney, and after it closed, Bill actually requested that certified court order, and we received it. We closed. Maybe it took about 2 weeks for the court to get it to us, and then we get an email 3 weeks after the closing from a paralegal at that attorney's office saying, "Hey, we just received the court order," and we had to tell her, "Hey, we closed 3 weeks ago. It's been 5 weeks since the hearing." So, so it's really, really, really important that they reach out and
Yeah.
do that.
Absolutely.
I
Absolutely.
think that's about everything for the bidding process here. Hopefully
I
that
think
was
so. I think
informative.
we covered
for
most
people.
points.
Yeah, if you have any questions for us, because there's a lot of people have a lot of questions for us regarding this process, please reach out to us. And really, what you need to know is full authority versus limited authority. Now, that's something that really touches on this process more, and that is a video we have next.